Hey everybody, and thank you for joining us. Welcome to the Georgetown Law Federal Society's Fall Symposium, titled Impeachment and its Implications for the Separation of Powers. Over the last decade, Congress has relied, with mixed success, on impeachment proceedings to assert its institutional prerogatives, engage in vigorous oversight of the executive branch, and amplify certain narratives. We hope that this symposium will encourage serious discussion and debate regarding the future of impeachment in America. This panel discussion covers views from the White House and Congress in a, quote, clash of the constitutional titans. We are thrilled to host both Ms. Kim Ham and Mr. Robert Ray to discuss this critical topic. Both of them have truly been on the front lines here. I'm now glad to recognize Willow Clark, our director of the symposium, to introduce the speakers. Thank you, Willow. Thanks all.
Kim Ham is the leader of Mayor Brown's Congressional Investigations Practice. She formerly held high-level government positions, including Chief Counsel to the Chairman of the Securities and Exchange Commission and General Counsel to the Speaker of the U.S. House of Representatives. As General Counsel to the U.S. House of Representatives, Speaker Kevin McCarthy, Ms. Ham provided strategic guidance to House committees on congressional investigations and oversight, including the issuance and enforcement of committee subpoenas to agencies and private parties. She also served as the Speaker's representative on the Bipartisan Legal Advisory Group, which articulates the House's position in litigation matters. Former Speaker Nancy Pelosi and then Republican leader Kevin McCarthy praised Ms. Ham's invaluable legal counsel and representation to many of the committees of the House, greatly assisting them in fulfilling their constitutionally authorized oversight roles, protecting confidential committee communications with the executive branch from disclosure, and defending the House's oversight and investigations prerogatives when challenged in litigation. She is a graduate of the New York University School of Law and the University of Florida. Robert W. Ray is a prominent litigator and former federal prosecutor and independent counsel for the Whitewater investigation. He is a respected courtroom veteran who aggressively advocates his clients' interests in white-collar criminal defense matters, corporate governance, and compliance issues, internal investigations, and general litigation, including civil RICO, FCA, FCPA, and commercial fraud. Mr. Ray joined the Independent Counsel's Office in D.C. in 1995, where he supervised, conducted, and participated in complex, long-term, and multi-defendant federal prosecutions involving public corruption. As the successor to Ken Starr, as head of the Office of the Independent Counsel, he investigated and issued the final reports on Whitewater, Monica Lewinsky, the White House Travel Office matter, and the White House FBI files controversy. Since January 2020, he has represented President Donald J. Trump before the United States Senate in his first impeachment trial, as well as before the U.S. Supreme Court as amicus in the Colorado Supreme Court ballot access 14th Amendment litigation. He is a graduate of the Washington and Lee University School of Law. Please give another thank you to our amazing speakers.
Thank you. Should I start? I'll start. I'll give Congress's view first, the most important view. Thank you for inviting me here today. I'm really looking forward to today's discussion. I hope, please feel free to ask questions, and I really want it to be sort of an interactive opportunity for everyone here. So when I was invited to speak, the invitation letter described the panel topic as impeachment as an oversight mechanism. And that's sort of an interesting and notable way to frame the issue, because impeachment is really the ultimate oversight mechanism when we're talking about Congress's oversight of the executive branch. It's sort of the apex predator of oversight. But taking a step back, Congress has broad investigatory power both inside and outside the context of impeachment. So why is the impeachment label important when Congress is gathering information that might lead to charges of serious misconduct about, from a president or a cabinet official, or more commonly a judge? More precisely, is that label of impeachment necessary to obtain information about misconduct that might lead to evidence of high crimes and misdemeanors? This question is one that's really specific to the House, because the House, under the Constitution, has the sole power of impeachment. The House's role is analogous to a grand jury. It gathers information, decides whether to indict, or more precisely, whether to adopt articles of impeachment. The House is the one that's conducting the initial investigation. One answer, though, to the question of whether the label of impeachment matters in terms of the investigative power is the view that when the House is engaged in an impeachment proceeding, it's operating at the zenith of its power. And we heard that a lot, in when the Biden impeachment inquiry was opened and when the resolution was adopted, and members would say, well, we're operating at the height of our power, the zenith of our power. But to understand what they mean by that, what members mean by that, we have to drill down a little bit on Congress's standard legislative investigative power. The Supreme Court has recognized that that power is broad, it's indispensable, that Congress needs information to legislate. And Congress's investigatory power in the legislative context is exercised by committees pursuant to chamber rules. So the House and the Senate issue rules, the committees are given jurisdiction under those rules, and they're given tools like document subpoenas, testimonial subpoenas to compel information. Committees, when they conduct oversight, though, are constrained by the jurisdiction that's set forth in the chamber rules. And a committee that acts outside of that jurisdiction is essentially acting unlawfully. It's acting without authorization from the House or the Senate. But these grants of jurisdiction by the House and by the Senate are very broad, and successful challenges to jurisdictional authority are pretty rare. And if you look at some of the grants, like if you look at the House and Oversight, it's the House Oversight and Accountability and Reform Committee. The old name is the House Oversight Government Reform Committee, but the House Oversight and Accountability Committee has been given very broad authority by the House to investigate. They can review and study on a continuing basis the operation of government activities at all levels, including the executive office of the president. Now, I think the executive office of the president might sort of disagree with that grant, but that's the House's view as to this committee's authority. And the House Oversight Committee can conduct investigations of any matter. The investigators there like to say, any matter, any time. That's our jurisdiction. And again, I think there can be debates about that, but that is what the House has delegated down to that committee. So why do we think of impeachment as something higher than that? Why is it the height of Congress's power? Is impeachment does it somehow bestow the House with the normal oversight, authority, and tools plus something extra? And the House's actual institutional view is no, it doesn't. And that instead, when the House says, well, we need an impeachment because we're acting at the height of our power, it's really reflecting practical considerations about how investigations are conducted and the political realities. So it's a defensive reaction in many ways to judicially imposed limitations on congressional oversight and what is viewed as executive branch intransigence in the face of congressional demand. So when you say we're at the height of our power, it's really like the height of our defensible power. And it's really, a lot of it is premised on the idea of litigation. Now, as an aside, Justice Thomas would disagree that Congress can ever issue a subpoena to get private, non-official documents, has to go through the impeachment process if it's the president, and if it's a private citizen, they can't do it at all. But that's not the prevailing judicial review at this time. But going back to these practical considerations, like I said, it's litigation. More and more, the working assumption of House investigators is that disputes with the executive branch over access to information will be litigated, that a subpoena will be issued, the executive branch won't fully comply, and litigation will ensue. And there are open legal questions about whether the House has the authority as the standing to litigate subpoena cases in court. And there are also open questions and debates about whether the House using litigation as a strategy to get information or conduct oversight is actually counterproductive to the House's constitutional authority to conduct oversight. Is it counterproductive? Is the House, when they go to court, our power sort of chipped away? But regardless, more and more, litigation is seen really in the early days as something that is on the table and may be necessary. And I say more and more there are members of the House who just want to go to court. this is a bipartisan issue, that it's seen as action, it's seen as a concrete, specific thing that members can point to. And when you're talking about, really tight majorities and divided government and policy, it being hard to move policy forward, oversight is the thing that members gravitate to. And in divided government, oversight of the executive branch is really a thing that members gravitate to. And again, litigation is seen as something you can point to folks back home. Look at what we're doing. So, but the litigation point is that if you're in the impeachment context, the view is that you have a stronger case if you go to court. And this is because congressional oversight has to be tied to a legislative purpose. I talked about the rules. And if someone is resisting oversight, they'll say, well, this isn't for a legislative purpose. This is harassment. This is pretextual. What you're really trying to do is, investigate misconduct for impeachment, or you're trying to expose private affairs, and you're trying to be law enforcement. You can't do that. And so, in an impeachment inquiry, the constitutional purpose is the impeachment. It takes away those arguments, right? And so the theory is you go to court. The court, the executive branch resisting complying with these information requests won't be able to make those arguments. They can't say it's pretextual because it's all on the table. It's impeachment. They can't say it's outside of the committee's legislative jurisdiction because it's impeachment. And so the theory is that those arguments are taken away, and that courts would have a more favorable view of the House's position, the House's need for information. It might encourage prompt judicial review. It might even encourage voluntary compliance because the executive branch will say, "Oh no, if we go to court, we're not going to win." Those are somewhat questionable propositions, honestly. And the idea of prompt judicial review is really the one that's the hardest for the House to overcome. A House committee investigating anything is on a 2-year clock, and they understand that. The executive branch understands that. The judiciary understands that, and to assume that you can get prompt judicial review, that's a hope more than a prediction. What are the political realities? Like, why don't you just rely on your regular investigative authorities if you're a committee? Why do you want to go to impeachment? Well, the decision whether to proceed via an impeachment inquiry is one of political will. Is there the political will to tell the public that this is what you're actually doing? Impeachment inquiries are often launched by a vote of the full House. The full House gets together and says, yes, this is what we think our committee should be doing. It doesn't have to be. That's Congress's view. The White House has a different view. But Congress's view is an inquiry can be launched without a formal vote. And there are lots of examples of that. There are examples of that in the 80s with judges. There's the first Trump impeachment is an example of that. The Biden impeachment inquiry is an example of that. There was an inquiry announced before there was a formal vote, but eventually the vote came. So why would the House want to do this vote? Like I said, the White House takes the view through OLC opinions that a vote of the House is necessary. There are some sort of other political considerations there. The House can decide if they have a resolution saying we're going to open an impeachment inquiry. They can decide which committees are involved. They can put sort of procedural limitations on the committees. They can try to scope out roles to avoid turf wars between committees, which you sometimes see. Committees have special rules about member access to records. Maybe a resolution would kind of resolve some of those issues. When will records relating to an impeachment be available to all members? Can members sit in on deposition? There are all sorts of things that the House can scope out and that they might want to scope out in terms of this resolution. And they can also pre-authorize litigation in support of subpoenas. And we saw that with the Biden impeachment inquiry resolution. There was a parallel resolution at the same time that said, oh, and by the way, if these issues need to be litigated, House counsel can go to court right away. The entire House has agreed to that. And finally, a vote puts members on the record. And some members really want to be on the record. They want to be able to show their constituents that this is what they're doing and that they support it. Some members really don't want to be on the record. They might support an impeachment inquiry, but they're in a district where that's not helpful for them. Leadership has to balance that. They have to balance those considerations when they're thinking about the vote. And the last thing I'll say is it is actually helpful to the accused. I mean, it provides
clarity.
It provides, transparency about what the House is doing. It will set into motion a series of potentially and hopefully, protections for the accused, due process considerations, things that actually the accused in an impeachment investigation wouldn't have in a normal sort of like congressional hearing. And in a way, it limits the House's authority in that way because some of the protections the accused should have in an impeachment inquiry, they would not normally have. But all of that said, I think that the big issue for Congress going forward and that they have to grapple with is whether going down the entire impeachment road, having to vote, doing this over and over and over, in the end weakens Congress's oversight authority generally and weakens its impeachment authority specifically. I think I'll pause there.
No, that's I think a fair question. That's where I'll start. I guess, for all of you to think about, for the country to think about, is whether the current road that we are on is in the best interest of the country. So sort of hold that thought, and let me see if I can offer some historical perspective. 25 years ago, tomorrow, I became independent counsel. And what you say sort of at this event, like, well, what do I know about impeachment? Not really much based on my background. I came to Ken Starr's office, to the Office of Independent Counsel, after impeachment was over, with really only one or two significant tasks remaining, the first of which was, what do you do about President Clinton, who was still in office, and what are you going to do about the investigation once he leaves office? The remaining decision is sort of the tail at the end of impeachment. Remember that once impeachment is over, no matter what happens, the accused, whether convicted or acquitted, remains subject to the criminal justice process according to law, right? So that's kind of we know all the things at the front end of what happens, and you've discussed all the things that go into how do you get the impeachment inquiry started and sort of the constitutional mess that is currently right now. That's separation of powers in action, right? The clash of the constitutional titans is, just speaking about presidential impeachments, you're talking about a proceeding initiated in the House to decide whether there's bribery, treason, or other high crimes and misdemeanors. That's really the only role that the House plays, a significant one, but they essentially return charges, articles of impeachment. And what's the standard? The standard is bribery, treason, or other high crimes and misdemeanors. Or Gerald Ford used to say, the standard really, truly is, it's whatever a majority of the House of Representatives decides. What's an impeachable offense? You have to decide, we as a country have to decide, are we going to kind of navigate in fuzzy thinking land, or are we going to really require that we sort of narrowly tailor what is, I think you've correctly isolated the point, there is something grand about an impeachment, right? Especially if it involves a president. What's the other significant thing going on? Once you have articles of impeachment, if it goes over to the Senate for trial, what's happening over there? They're under oath or affirmation, so I think it's intended to kind of convey the notion this is a pretty serious deal under the Constitution. It is. If it involves a president, who's present besides the 100 senators? And by the way, they all have to be there. That's one of the sort of the unique features of going and doing an impeachment defense argument before the United States Senate. You show up. It's not obvious to people on TV, but you show up. I'm in the well. I'm talking to the entire United States Senate. All 100 of them are there. When does that ever happen in today's world? Never. Who's presiding? If it's the president. The Chief Justice of the United States. Now, people argue about, well, is that sort of a ministerial role? Like, why is he there? I can tell you that the Chief Justice wasn't really all that happy. It was obvious to me he was not all that happy of having to be tied up for an impeachment trial for several weeks, outside of sort of his normal responsibilities as Chief Justice of the United States. But there's a majesty in that, right? I mean, it is the clash of the constitutional titans. In one room, one branch of government, the Senate is the jury, presided over by the Chief Justice of the United States, another branch of government, and the person who's in the dock is the President of the United States, the third branch of government. Again, when does that ever happen? So that's where all this is headed if it actually makes its way to trial. But from the perspective of 25 years ago, when I became independent counsel, many of you weren't born. What was the model then? The 1974 impeachment proceedings of Richard Nixon. That was really the only other model that was out there. And I remember that because I was old enough to remember I was 14. So, I wasn't like a legal scholar, but I was there during the summer with the TV on all summer long, listening to the impeachment proceedings before the Congress. It was like the biggest window or education seminar ever about the functioning of your government. It was on TV every day. It's not like now where, almost everything about government in one fashion or another is accessible in some form or another on TV. Then that was a pretty unusual thing to be telecasting to a national audience where there were only 3 networks and everybody in the country was watching wherever they were, wherever they could grab a TV set to watch what was happening, to their government. And so that was the only model for me. And if you went before 1974, what's the history of impeachment? Aside from the impeachment of federal judges, which did happen, but taking on a president was almost unthinkable. It hadn't happened since 1868. President Johnson. And even in that situation, the president was acquitted by 1 vote. And history generally regarded it as being somewhat of a misguided effort because really what we were trying to impeach him for, you were trying to impeach him because he didn't do his office very well. You didn't like the fact that he was president. Abraham Lincoln had been assassinated. Who is this person? The Northern Republicans weren't all that thrilled with how he was conducting himself vis-a-vis Reconstruction, and it was very favorable to the South in their perception. And they, on sort of trumped-up charges, said the articles of impeachment were the violation of the Tenure in Office Act. He fired Edwin Stanton, who was Abraham Lincoln's Secretary of War. Well, let's just start with the notion that the Tenure in Office Act would be reasonably have been viewed by the executive branch and the president as unconstitutional, as it eventually found was so. So the track record for presidential impeachments was not a particularly good one or happy one or any sort of roadmap, and we didn't really arrive there until 1974. Now, since then, what's happened? Well, we've got this one from 1974. We've got another one of Bill Clinton in 1999. We've got the first Trump impeachment in 2020 and the second Trump impeachment in 2021 and Mayorkas and Biden. And, so now we've gotten to the point where we sort of open up impeachment inquiries, I guess, because we have to. Because if we don't and have a full vote of the House, we have an intransigent and recalcitrant executive branch that won't provide up things that it claims sort of weakly are privileged. And we're sort of traveling down the road of returning articles of impeachment that may colorably be a stab at treason, bribery, or other crimes, high crimes and misdemeanors, but probably really aren't. We're really sort of targeting like malfeasance in office, which really shouldn't be and never was seen to be grounds for impeachment. I guess we had thought the lessons of history from the Andrew Johnson impeachment that was not a particularly fruitful way to travel, but we sort of have kind of defaulted to that now and opened it up, I guess, to an environment where we're going to have to sort of live with the notion that we may have impeachment as sort of a routine matter. My own view, for whatever it's worth, this is one person's opinion, is that it still has to be grounded in, or should be grounded in, the country's best interests in something as important as treason, bribery, or other high crimes and misdemeanors. I mean, I'm done with like fuzzy thinking and the lack of clarity in the political process. I mean, understandable why things develop the way they do, but still sort of at rock bottom return to the notion that it is a grand proceeding. It is the clash of the constitutional titans. You ought to have a good reason for impeaching somebody. Malfeasance is not one of them, in my view. We do not have, through the impeachment process, at least in my view in this country, the notion of a vote of no confidence, which is sort of what it's become. I mean, your vote of no confidence in the system that we live in is, hello, what we're about to have in November next month is an election. You don't like the person who's there. We have certain institutional protections to deal with that. It's called voting them out, which was one of the things that was sort of, to me, so colossally stupid about the Colorado Supreme Court litigation. I mean, are you kidding me? You're going to institute a litigation that the press all deemed to be flawless logic by the Colorado Supreme Court and on to the Supreme Court of the United States, which, by the way, captured no justice of the Supreme Court, so it wasn't a partisan resolution. It was a bipartisan recognition that the Colorado state election authorities had no business deciding who was and who wasn't on a ballot for president of the United States. I mean, how can you allow a system like that to exist without having federal involvement? And in the wacky system that we're in now, with special counsel regulations and divesting the Department of Justice of authority on the notion that we should have some independence and have an independent view of these things, and the Department of Justice shouldn't weigh in with regard to Trump's interests because they're conflicted, and all these things, you were leaving the Supreme Court of the United States to sort of express the views of what should have been the Office of Legal Counsel to protect the institution of the presidency from encroachment by state election officials to decide who is or who isn't fit to be on a ballot because you dream up some notion that somebody is an insurrectionist. So, I have a hard time divesting this topic from like all the things in my life I have become familiar with, which is to say it's not just about impeachment, it's also about what happens after impeachment. Can you prosecute a sitting president of the United States while he's in office, with or without impeachment? How the hell do I know? I don't know. But what I do know are, there's some troubling features to all this. If you think the independent counsel statute is constitutional, I guess you can devise a reason to conclude that a sitting president could be charged with a crime. Now, in a unitary executive theory of government, that's incomprehensible. How can the president be charged? He has all of the executive power. He can't charge himself. But if you separate out an Office of Independent Counsel or a special counsel from the ordinary operation of the Justice Department, as Bob Mueller's prosecutors were apparently prepared to go, yeah, the answer is sure you can charge a sitting president. Office of Legal Counsel's opinions to the contrary be damned. And there's a certain, merit in that. I guess for those of us who believe that there's serious question about whether Morrison versus Olson is the correct law of the land and should, ultimately be probably cast aside. And as Judge Cannon found in the classified documents litigation that's now presently before the 11th Circuit, the special counsel regulations for the same reason are unconstitutional. They have a funding mechanism which is a vestige of the independent counsel statute, which has since been sunsetted and abolished. So how does that funding mechanism fund something that's no longer in existence? And the special counsel regulations put somebody in power with an enormous amount of authority that ordinarily under our system, if Justice Scalia is correct, require a presidential appointment with the advice and consent of the Senate. And in an ad hoc way, from the lessons of history, which people seem to so easily forget, that's what worked during Watergate. Leon Jaworski, in effect, was an appointment that President Nixon, against what he wanted to do, but politically was forced to, at least acquiesce in that appointment, which made it his appointment. And he did so also with the relinquishing his ability to terminate that office. And with essentially a gentleman's agreement, so to speak, that he wouldn't do so unless he consulted with key members of Congress. So that, in effect, was sort of duplicating, or at least paid homage to, lip service to, the constitutional requirement, if you're going to appoint somebody significant, they should be a presidential appointment with the advice and consent of the Senate. It wasn't exactly like a confirmation process, but at least it was, this is Robert Bork who devised this, he came up with the ability to appoint Leon Jaworski in the political process that at least paid some attention to separation of powers in action. We have completely lost sight of that. That's just like out the window. The special counsel regulations are essentially a successor to that contrary tradition. Oh, no. The wise people of this world will decide that we will separate out, because it's so important, take it out of the political process, and have the Attorney General make an appointment outside of the Justice Department. And to the point where I was on TV not that long ago with the announcement of the indictment in the D.C. case, in which Andrea Mitchell was on TV and I was on the set at the same time, making the argument the special counsel, of course, has nothing to do with the Department of Justice, is completely separate and independent. Joe Biden has nothing to do with this. Now, neither really does the Attorney General once he makes the appointment. And the special counsel comes out, Jack Smith, stands at the podium. I'm on TV, Andrea Mitchell's making this point, and he's announcing the indictment to the country under the seal of the Department of Justice. It's like, wait a minute, what's wrong with this picture? You're claiming on the one hand that he's independent, on the other hand, he's right on a podium with the seal of the United States Department of Justice. I mean, this is how wacky things have gotten. My sort of pitch to you and for the country to think about is to just kind of return, to some clear thinking about what impeachment really means. It should be, there should be a certain majesty to it, I think. It should be an area of last resort. We've lost that in this country too. I've always believed that prosecution, whether it be of people that you've never heard of to prosecution of former presidents of the United States or current presidents of the United States, prosecution is a last resort as well, just as impeachment should be seen as a last resort. We have gotten to the point in this country where if you can do something, go ahead and do it. I don't believe that about prosecution. Yes, under a certain view of the world, you can indict a ham sandwich and send the ham sandwich to trial. No responsible prosecutor would ever do that. Why? Because even under the principles of federal prosecution, your obligation is a higher one. It's not just about whether or not you have probable cause to believe a person committed a crime and could get a grand jury to indict that person. No, your obligation is, I'm only going to bring a case if I have a good faith belief that a fair-minded jury would convict the defendant unanimously, beyond a reasonable doubt, and that conviction was sufficient to be obtained that would survive on appeal. I don't get any sense at all, for example, that Jack Smith's view of the world is that way. And I don't think we can operate it in an environment like that. Similarly, since our topic is of impeachment, I don't really think it's responsible. Impeachment inquiries are one thing, and there's a certain need to kind of get that underway and navigate that process through the court system to make progress. I do get that problem. But I don't think you should be bringing impeachment proceedings unless you have a firm belief in the House of the likelihood of success of that proceeding in the Senate. What's the other significant difference in the Senate? We talked about, there's like 4 of them, right, under the Constitution. The first is that the Senate has the sole power to try impeachments. The second is that the Chief Justice presides if it's the President. The third is that it requires that they be on oath or affirmation, which again I suggest to you means something more. I don't know what that something more is, but it's got to mean something more. And the last is that it's got to be 2/3. So the system is designed to make that an exceptional event. And I always thought that was pretty exceptional. If even in the Andrew Johnson situation, you came within 1 vote and you still couldn't do it. Now, with the benefit of history, I think the consensus seems to be Andrew Johnson had a point, right? They impeached him for something that was based on a statute that was an unconstitutional encroachment, which sort of gets back to, again, this is all about really what's going on is separation of powers in action. This is not just a an exercise in political theory. This is, a real question of, major powers having a confrontation and doing battle with regard to significant events. But I guess my suggestion is, for the future, whether it's possible, who knows? It'll be up to all of us, I guess, to sort of figure that out, sort that out. It should be reserved for those unusual situations. It should be the exception rather than the rule. I don't think it's healthy for the country to be engaged in a process where every 4 years while the president is serving, we're going to have an impeachment inquiry up and running. I mean, I'm already imagining if Trump is elected president that, within, it won't take but a year or until, if Congress or if the House, turns into to Democratic hands, let's say 2 years, for there to be an impeachment inquiry, up and running. I mean, do you think that that's healthy? I mean, I don't. I mean, I go through these things with just, my reaction is, don't we as a country have more important things to be worried about? Now, the flip side of that is that if you seriously want to investigate your way through things to find out whether or not they're impeachable offenses, now we've gotten to the point where you can't even get over the privilege flag from the White House unless you're prepared to open up an impeachment inquiry that carries the whole House's vote. And then it almost sort of inevitably pulls you toward they're going to impeach, making it almost a foregone conclusion. I don't think that's the way we operated during Watergate. I think that's probably the way we need to return. Watergate ultimately became, down to like he didn't have the votes. Nixon, didn't have the votes in the Senate, was going to lose. So Barry Goldwater went to him and said, sorry, Mr. President, there are going to be Republican votes out there you're not going to get, and you may not get mine. That was it. He was done and resigned. If we're going to take on presidents outside of the electoral process, it seems to me that we should have a very, very good reason to think that it will be successful in the Senate before we travel down that road. Otherwise, we're going to just be in an endless, circle of things that really doesn't lead anywhere. And I don't think that's healthy. So I guess my parting message on that is, like prosecution, I don't think we should be doing things unless we're reasonably secure in the belief about what the outcome should be. I think that we should get out of the business of using impeachments or even criminal legal proceedings as sort of another way of going about politics to do damage to the other side. I don't think that's a good and sufficient reason to be returning an indictment against anybody, and I don't think it's a good and sufficient reason to be bringing articles of impeachment against somebody. You don't like it, hopefully the president, enough political pressure is brought to bear that the person resigns. If that doesn't happen, the recourse should be the next election cycle. It shouldn't be run off to the House to commence impeachment proceedings to see if you can take them out or do damage to them that way. And then, I do think we have to think about sort of reordering our priorities to be a little clearer about what the standards are going in. I do think it shouldn't be a routine matter. I think we ought to think about the fact that just like it sounds, bribery, treason, or other high crimes and misdemeanors sounds kind of like a bar to me, doesn't it to you? That's where we should go.
Yeah, thank you both. This was really great. Kind of first question here, moving toward the Q&A, is Ms. Ham, if you have any response to that really outstanding statement, any thoughts on that, but then also for both of you, if your experience working on these issues firsthand changed your mind about any of these issues sort of while you were in. Thank you both.
Yeah, well, I do have a couple reactions, and I think Bob has made really good points on the election piece. It does seem as our electorate has the ability to become more and more educated in real time about what actions the president is taking. Television news, social media, 24-hour news cycle. That now, impeachment or impeachment inquiries are more common, and really, elections should be the baseline of how these decisions are made. And if for example, if Trump is elected president, in November, it'll be clear that the electorate has said, regardless of what has happened with impeachment before, he's our choice, right? And so, you can't and you shouldn't underestimate the power of the electorate and the fact that they're informed. They are informed. And 100 years ago it would have been different in terms of their ability to have information about sort of what was going on in the executive branch in real time, and Congress was in a better position. But that's different now. On the impeachment inquiry point too, I think Bob is right. My Congress's view, my view as well, is that the legislative investigative authorities are so broad that lots of information about the executive branch should be available to Congress, and the fact that there is a view that an impeachment inquiry provides these sort of practical benefits of better arguments in litigation, maybe get the information faster, and that's all true. It does then become sort of inevitable, or at least for some people it's inevitable. So I believe that if you're going to open an impeachment inquiry, you should not have a predetermined result. It should be okay to end it and not end it with a recommendation of articles of impeachment.
Yeah, and I totally agree with that. I mean, in a perfect world, I think that's exactly right. The problem is that we're increasingly dealing in an imperfect world. It's just hard to stop the snowball from running down the hill when the snowball starts. Once you begin an impeachment inquiry, on the other hand, I totally get the notion that would you ever know whether or not you really have evidence to sustain articles of impeachment at a trial before the Senate if you can't even get subpoenas complied with to obtain the information necessary to build that case. That's the problem.
Yeah, and the inquiry piece, there will be criticisms on both sides. So members who support an impeachment inquiry will, in some cases, many cases, be very critical that inquiry does not end in an impeachment. And then on the flip side, the party that doesn't support impeachment, and we saw this last year, will say, how can you open an impeachment inquiry when you don't know if there's been an impeachable offense that's happened? It's like, well, that's the point of
the whole point,
right? And so it just from both sides, there's sort of a criticism of this process, but I would say from both parties there is a recognition that hope that certain tools are unlocked. I mean, I would submit that that's not really the way it should be, and that you're kind of ceding authority to the courts. And if you're talking about congressional investigations generally, impeachment, regular oversight, often the authorities are chipped away when you get to court, and we've seen that. We saw that from the Supreme Court in the Mazars case. Nominally a win for the House, but setting forth a new multi-factor test about when congressional subpoenas seeking presidential information can be obtained, and dicta in there about how Congress recognizes common law privileges like the attorney-client privilege, which congressional investigators will say that we absolutely don't. And so it's not necessarily a desirable result to end up in court, because you as the House of Representatives, as a branch of government, are essentially saying, I will let this judge or this the panel of three circuit judges decide an issue that the entire House has decided should go one way, and I think that's maybe not a great place for the House to end up often.
Well, you asked about what I learned. Let me go back two things. One was when I was in independent counsel investigations, one of the things I learned, which goes to your point about where we are right now, is the court system is being used to gum up the works and preventing the Congress, the House in particular, from doing its job. One of the things I learned during the independent counsel era is we faced many of the same issues in a related context. Grand jury subpoenas would be outstanding to gather information on behalf of the investigation, and they would be met typically with objection to the subpoenas and a motion to quash on usually very frivolous grounds, the first of which was that the independent counsel lacked authority under the mandate, the mandate of jurisdiction that provides the office with the power, the full power and authority of the Attorney General to act in a particular area. So they'd file a motion to quash. Well, every motion to quash in the district court in D.C., now this is a criticism of the federal judiciary, but not at any particular judge, but just take it for what it's worth. The defense bar very quickly saw the advantage of slowing down an independent counsel investigation to just slap a motion to quash with regard to pretty much every subpoena that was issued, which would cause the investigation to stop until that matter was litigated. Well, one of the peculiar features which the defense bar takes advantage of in D.C. is that in the district court in D.C., unlike where I'm from, which is New York, which has a rotating Part 1 judge that handles matters that come in the ordinary course every week, and every week there's a new judge that gets assigned to deal with Part 1 matters. So something like a motion to quash before a grand jury would go before a Part 1 judge, and you really couldn't form shop because you didn't know who that judge was going to be, and in any event, it changed every week or every couple of weeks to a new judge that would be rotating among the active judges in the Southern District of New York, which is what I'm familiar with. In D.C., it doesn't work that way. So here's sort of one of the peculiarities of practice, just to understand. Every routine motion like that in the ordinary course, not assigned to a judge, goes before the chief judge, where all of those matters just stack up before one judge, and that chief judge has to act on them in the order in which they're received before you make any progress to get a resolution of that matter. That's a mess. I don't know why that system is still allowed to go forward, but one of the problems in the Congress is, since they're only there for 2 years, right? That's a Congress. Is if you got an impeachment investigation, and every time the House tries to act to issue a subpoena or something, it's going to be litigated, and it's going to land in the district court in D.C., and it's going to sit on one judge's desk until, in that judge's chambers, until that gets resolved. It's not hard as a defense lawyer to figure out if you want to gum up the works. It's not hard to gum up the works, right? So I don't know why that's tolerated, but it is. That's what happens. And now we've gotten to the point where, of course, every legitimate investigative step that's taken either by a prosecutor or by the House is going to be met with the reality of having to litigate through the court system. And sometimes it has peculiarities that just, are a vestige of a different era, but aren't well suited to modern times. In fact, it got so bad in the first of the two independent counsel investigations that I was a part of, which was Don Smaltz's investigation of the former Secretary of Agriculture, Mike Espy, who ultimately went to trial. We indicted him. He was acquitted in the District of Columbia. But all during the investigation, as my sister-in-law Elizabeth knows well, who's here, who worked for Don Smaltz, we would send communications to the chief judge with regard to all of our pending matters. These are all the things that are waiting for you to decide, Judge. And it got so bad that we started sending stuff over in color-coded. Well, these are the ones that have been pending for 30 days. These are the ones that have been pending for another color, 60 days. These are the ones that have been pending for 90 days, more than 90 days. So we have these beautiful things in this era from the middle to late 1990s with the color-coded graphs to send to the chief judge to say, please, there was nothing we could do. All we could do was plead. Please decide these things, because until you decide these things, we can't move forward. Well, what was it really going on, by the defense bar was running out the clock. You have a limited mandate. You're the independent counsel. You're not constituted forever. You're not going to be around, forever. And every time that you're doing something, you're in the newspaper for how much money you're spending and how long it's taking before you're making any progress. In the meantime, we're sending over color-coded charts to the chief judge of the district to try to get our litigation matters through the court. So that was sort of the first real-life experience I've had, just to give you some sense of we can all talk about this stuff in terms of political theory. Well, there's some practical things that are going on here. That's one of them. That's a difficult one to overcome. It stalls your investigation. Second thing was, I go before the United States Senate many years later to argue on Donald Trump's behalf in connection with the first impeachment. I'm defending him. What am I defending him? I'm defending him at the trial. So you sort of think, well, okay, that's pretty simple. You're defending him in a trial to try to convince something greater than 1/3, that to stay with the president so he doesn't get convicted. Well, that kind of was the overall objective. But in this sort of weird world that we're in, there wasn't really any chance that Donald Trump was going to be convicted by the Senate and removed from office. That was already a foregone conclusion. We knew the result before we even started. But doesn't mean that there can't be political damage along the way. And what I found myself in was not really so much an argument about that, which was like how to convince the necessary number of senators to keep him in office and to quit him. Really what the argument was about was whether or not the thing would move forward at a trial to whether there would be witnesses or not. And that became kind of something where that was a closer vote, about by a majority of sort of like, oh, well, yeah, I'm probably ultimately going to vote to acquit Donald Trump, or at least the votes aren't going to be there to convict him. But are we going to have like a trial, or like a show trial, or are we going to have like a real trial? Like, oh, is there going to be witnesses, and are there going to be depositions before that? And like, are we going to actually present evidence, or are we going to just talk about it? We're going to subpoenas?
Yeah.
And all these things, in the Constitution, there's no roadmap for any of this. Do you see any procedures in the Constitution about talking about like what the trial's supposed to look like? No. Is there really anything in the Constitution about like how the House decides whether articles of impeachment should be returned, other than the sort of the standard of high crimes and misdemeanors? No. Is Gerald Ford right that an impeachable offense is whatever a majority of the House says it is? Well, yeah, at a practical level, yeah, he is right. That's kind of the balance that's going on here. I can talk about lofty ideals about you shouldn't really be impeaching anybody until you think you have a reasonable chance of convicting them, but all this stuff is kind of a fluid process and a clash between, the big kahunas, right? The president, the Chief Justice of the United States, the House and the Senate. This is like a real lesson in action. One of the beauties about being independent counsel is you got like exposure to all these people. The Chief Justice, the leaders of the major committees in the House and the Senate, the White House counsel, the White House, the Justice Department, the Deputy Attorney General, the Attorney General, like all these people, like, yeah, okay, this is like, bring it on. But I found myself in the middle of an argument really trying to persuade one United States senator, not 100, one. Nobody captured the moment, but this was what was going on really at the time. I was trying to persuade Lamar Alexander not to vote in favor of opening up the proceeding to witnesses. If it had been opened up to witnesses, that's a political mess, and that's unpredictable, like most trials. Like, you start talking about bringing people in for testimony, you lose control. You have no idea where that's going to go. And probably if you're defending a client in that situation, you do know one thing, it's going to go someplace that you don't want it to go. So the real vote there wasn't about conviction or acquittal. That was a foregone conclusion. What I learned, your question, well, what you learned through this process that you didn't expect, what I learned was it really became something about I had no idea it was about. It was about convincing one United States senator to, stand behind basically the Republican position and vote no on witnesses. That's what I was there to do.
I can take one more. Any other questions? We got about 5 minutes left. I think the other one was Ms. Ham for you. How was it with a very narrow Republican majority trying to move on impeachment and toward the inquiry?
Well, I think with a narrow majority, whether that's a narrow Republican majority or if there's a narrow Democratic majority, it's very challenging. The House members have lots of different views, not just about impeachment, but about everything, and lots of different approaches to how the House should govern itself and how the House should, preside over these kinds of proceedings. And there are members who come from, swing districts very tight races. There are members that are worried about getting primaried, and so all of those factors come into play. I mean, the easiest way to say it is just it's just hard in a tight majority to get a majority of, to get what you need is all of the conference to agree, right? And we saw that with Mayorkas, right? It comes down to sometimes if somebody got stuck in their district because the flights got canceled, or when you're talking about those kinds of numbers, it's like, somebody got sick, or somebody's son is getting married, and there are these calls being made that said, well, how late can you get to the wedding, right? Like, how much time do we have here? And so that's just challenging, and I think no matter what happens with the House election going forward, more and more our country, it's so close. It's so close to a 50-50 split. These challenges of getting anything through are going to continue.
And the unpredictable happens. I argued in the Senate, and you think you have some control over like the news cycle and how you're being received. And I argued in what dominated the news the next day. Kobe Bryant's helicopter went down. And the country just was completely absorbed by that news and really wasn't interested in anything having to do with impeachment any longer. That was, you can sort of argue about whether that was a benefit to the defense or not. But again, like anything else in a moment in time, it's like, just like we were saying, the unpredictable happens. It reminded me similarly when I announced the resolution involving Bill Clinton on the day he left office, that he agreed to things that I had as certain conditions, that I would exercise my discretion and not to prosecute him. It was sort of a big moment in play in time, to sort of confront the country with, I thought, the wisdom of, if possible, not saddling the new Bush administration with having a pending indictment against a former president, that was not in the best interest of the country, and if it could be avoided, that it was in the country's best interest to do so. And that moment was out there for all of about 30 seconds. What happened after that? Bill Clinton, on his way out of office, pardoned Mark Rich and the parade of people, and then the news cycle was completely dominated by the, quote-unquote pardon gate, and nobody was interested in talking about what it is we had just done, which in itself was a pretty momentous occasion, but the news cycle was dominated by something that, was completely unpredicted, although I sometimes wonder whether or not Bill Clinton did that for precisely that purpose, but that's a whole other story. So, those kinds of things in real life can happen, and sometimes are more important than we give them credit for. You don't have, some things in life you have control over, and some things you just don't. They happen. Stuff happens.
That's a good question. Like, what kind of compels you? I think I can probably get the answer from your dialogue specifically for you, Mr. Ray, but what kind of compels you to be a defense attorney for a president in an impeachment trial? Like, what do you find fascinating about that? I can kind of get an answer, but just want to hear your perspective.
Well, I mean, one, like, a very basic thing maybe sometimes is overlooked. I was asked. In some sense, it's not more complicated than it's kind of a hard thing to turn down, right? I mean, if the President of the United States asks you to do something, I think most people think, well, maybe I ought to think about, unless there's some really compelling reason why I can't, that's an important moment. So I think there's that aspect of it. Somebody needs it's also just as a lawyer, somebody is asking for my help. As one lawyer used to tell me, everybody's entitled to a defense. They may not necessarily be entitled to my defense, the defense that I would provide. So you do have, discretion to reject clients for whatever reason, or even for no reason. But the president asked. I kind of felt like, okay, well, that's important, right? I think second, just as a professional matter, like, who gets to argue before the United States Senate? Like, when does that ever happen? And like I was communicating before, like, when do you ever get the chance to actually have all 100 of them sitting in their chairs? Literally, they were like all tied to their seats, and they had to listen to me for half an hour. That was kind of if you're into power trips, that was kind of cool, right? I mean, don't discount the fact that some of the stuff is fun, right? And I've gotten to do those kinds of things in life, not too often, but arguing before the Supreme Court is kind of the same thing. There's like 9 of them there. You're not talking to just a court. You're talking to a branch of government. That's a cool thing. That's a pretty, weighty thing. There's 9 of them there. They're sitting there. They're tied to their seats too, and you get to argue. Like, hello, that's a pretty. And those opportunities, they come along. They'll come along for many of you. It's just like it's one of those things that just happens. But that's like don't discount the fact that there's that's kind of neat to be able to do that as well or not well as you're capable of doing at the time. I definitely felt like I completely fish out of water. It wasn't like I'd ever argued a case before the Supreme Court before, but that was an opportunity to do that. That's special. But yeah, to bring it back to at its basic level, he asked.
Like the reason I asked is because it's just like it seems like such a show sometimes, like these Senate trials, Senate hearings for impeachment. So obviously if I were asked, I would go too. But like it just
no, it was a show, and I don't know how well it was. I talked a big part of my defense there was to talk about at least what I thought I knew, which was compare it to the only other impeachment that I was, really familiar with, which was to think about, Richard Nixon and sort of the fact that for me as independent counsel, 25 years later in 1999, that was my roadmap for like how do you do the job as independent counsel? Well, I thought about it in terms of like, well, what if Leon Jaworski were faced with this, what would he do? And think about it like as a starter, at least in historical terms, about well, what's the roadmap for this? Okay, has anybody ever done this before? Well, and if they had, how'd they do it, and how'd they like navigate around the minefields? That was kind of my model, to think about it in those terms. So, you do find in those big moments to sort of go back to basics. Like I try to go back to, okay, well, what does this look like? Has anybody ever done it before? How'd they do it? What did you learn from that? I had the benefit of being in 2 independent counsel investigations. I learned things from watching other people try to do the job as well or not as well as they were able to do it. Nobody's perfect, but you learn some things. Your question, like, what'd you learn along the way? Those are the things I learned.